Hello, everyone. My name is Brady Campbell, and today I'll be presenting The Right to Respect, Article 1, Section 30, and the Rights of Crime Victims. But what does Section 30 really say? It's about victim protection. A crime victim has two automatic rights. They must be treated with fairness and with respect for the dignity and privacy of the victim, and they must be protected from the accused for the entire duration of the trial. Now, crime victims have five more rights they can ask for. They can be notified about court proceedings, attend court proceedings. They can meet with the prosecutor's office, which includes meeting with a state attorney. They have the right to restitution, and restitution in this case means compensation paid by a convicted defendant to a victim. And last, information about outcome. So conviction, sentence, and when the offender is released. And that last one is of special importance. We'll get back to that later. Now, there's several additional clauses that really make Section 30 work. Section 30 also allows the legislator to define victim and enforce these rights, and it also allows the state to enforce the right of the victims, which means the legislator, the state, and the victim themselves are the ones who are responsible for enforcing these rights. Which means police, prosecutors, and judges are not responsible, and they're protected from being sued if they fail to provide one of these rights. Now, more importantly, a defendant can't use a missed victim's right as grounds for appeal or for post-conviction writ of habeas corpus, which here means you have the body in Latin, and a writ of habeas corpus generally is a judicial order forcing law enforcement authorities to produce a prisoner they are holding and to justify the prisoner's continued confinement. And here, if this section wasn't in Section 30, an accused could possibly claim that the trial was unconstitutional because a victim didn't have these rights enumerated in the Bill of Rights. And so, because the trial was unconstitutional, it should be overturned and they shouldn't be allowed to continue to confine them, which would be a problem because this is meant for victims' rights and we don't want that to overturn their trial. Now, why was Section 30 added? Well, it's about a shift in focus. Texas's Constitutional Bill of Rights was originally built around the protection of the citizen's life, liberty, and property. Remember the reason for government, by balancing the rights of the accused against the power of the state. And most of Article 1 is about this. Search and seizure, due process, right to counsel, these are all about stopping the government from infringing upon your rights if you are accused of crime. But Section 30 is different. It's added in 1989, which is 113 years after the Constitution was adopted and after the first 29 sections of Article 1. So this represents a new part of the Bill of Rights, which is all amendments. This represents a shift to a focus on victims following the victims' rights movement of the 1970s and 80s, arguing that a compact between a government and citizens breaks down if the government protects the accused's rights but ignores the person who was harmed. And so, Section 30 pushes the protection of life, liberty, and property further. The government must not only be sure not to violate your rights, if you might be accused of a crime or not, but also affirmatively oversee restitution and other things after someone else violates those same rights. So this is even a further step in how the government is protecting your life, liberty, and property. Now, why is this important for Texas citizens? Well, not only lawyers and defendants, but ordinary people have a voice in their own case, so they don't remain bystanders, which was a claim in these early riots or rallies for victims' rights in the 70s and 80s, mostly for victims of domestic violence. Victims have access to pertinent information regarding their case, like court dates and release times, giving physical safety and peace of mind. Restitution can be important for recovering significant financial losses due to things like property damage or costly hospital bills. It can be financially crippling to be, harmed or your property destroyed, and even if you put that person in jail, you still need to be financially compensated. These rights being constitutional means it is harder to weaken or repeal them, i.e., it takes more than just a legislative vote. And this is very important because this is why we put this in the Constitution and not just rule this in a court of law as a precedent. And here are 4 pertinent facts to review. Section 30 was added by voters on November 7th, 1989. It is not part of the original 1876 Constitution. It's part of a bigger movement toward a focus on the constitutional protection of victims' rights, and more than 30 other states have similar things in their constitutions. The section specifically protects judges, prosecutors, and police from liability if they fail to provide one of these rights. It is the state and the victim's responsibility. A defendant cannot weaponize the failure to provide a victim's rights as grounds for an appeal or habeas corpus. This section is meant to protect victims, not be used to overturn their cases. Now, it's time for the part that you've all been waiting for, and maybe that you even skipped towards, the discussion questions. And here are the questions I have for you today. Should a victim's right to be present during a trial ever be withheld or limited to protect the defendant's right to a fair trial? What if the victim's testimony is shaped by other witnesses' testimonies? And lastly, who, if anyone, is legally responsible if a victim uses court-provided information, like a release date, to harm the accused? I'm really interested to hear your answers. Here are my references, and thank you for listening to my presentation. Have a good day.